Okay, we are live.
We're live. This is our weekly update. I'm Aaron Hall here this week with Rylan Warner and Zach New. And we're here, as always, to give our brief updates on some things in immigration news. And then if there are any questions, we'll try to address those as well. So, Rylan, do you want to get us started?
Sure, yeah. First off, I don't know. I don't like the framing here. I gotta match my head up with yours a bit more. I want people to think that I'm taller than you, but I just gotta be real. I'm not. So, okay. So I just had a really quick story this week. A story came out yesterday that Biden was meeting with the Congressional Hispanic Caucus in a private meeting to discuss what their concerns were with any potential issues that they wanted to talk about. And in that meeting, he did indicate that he will be extending DACA protections for at least another 5 years. And then also, he indicated that TPS, or temporary protected status, for Honduras specifically and Nicaragua would be extended as well. They would be redesignated for temporary protected status. Nothing official has come out in regards to these actual announcements. It's kind of an inside scoop from the Congressional Hispanic Caucus. The reason what caught my eye about it was the potential forgiveness of student debt. We'll see if that ever comes to be, but he is still at least talking about it behind closed doors. So, it's great that we're getting DACA extended. It would be greater to have better pathways for people that already have DACA, or just let's not keep these people in this perpetual limbo. Let's give them some kind of route to a green card. But we'll see if that happens. At least there are other potential routes for people that have DACA, but DACA on its own while it's great, it's not quite enough for us. We want more, and these people deserve better. So that's my story for this week.
So I have a question for you. They've been saying that they're going to release new regulations on DACA for a long time now, right? So do we have any sense of the timeline about when it's going to happen?
No, this was a CBS story, so it wasn't too in depth. And like I said, there hasn't been any official announcements from the president. It was just an inclination of what he intends to do at an unknown time in the near future. Hopefully, there weren't any additional details about the timeline for this. So unfortunately, but hopefully we'll see something soon.
That was my question too. Just as background for everybody, they've already completed all the preliminary steps needed to actually issue DACA regulations. So all they have to do is issue them. So it's been months. It's been like 3 months now since they've completed everything they needed to do, and we're just waiting on them to put something on the books. So it's we've been waiting with bated breath for a long time now.
Now, do either of you know, so when these new regulations are released, how do they interact with the court injunction that's in place? Does the injunction apply in any way, or will it be amended to apply in any way to the new regulations?
I don't think it would apply in any way, because it's all based off of executive orders that have been implementing DACA with actual regs on the book. I don't see how the injunction, as it is at least, could possibly apply.
So whoever wanted to stop it would have to start a new lawsuit, probably.
Mm-hmm. Or I guess they could go back to the court and say, okay, now we've got this, let's change the injunction to apply in this way. But I don't know how that could happen without a lot more briefing and just basically, like an entirely new lawsuit. So the court probably wouldn't even entertain that.
Yeah. Okay.
Cool.
Zach, you want to give your update?
Sure. So first off, I wanted to quickly amend my comments from a couple of weeks ago when I said the H-1B numbers were not released. They were released like 8 hours after I said that. So yeah, it was actually like 485,000 registrations in total have been conducted this year. So yeah, my comments still stand. It took way too long, and a lot of the data is super weird. Like for example, the special visas set aside for folks who have master's degrees, those increased by 1% this year, whereas just the regular H-1B registrations increased by something like 60 something percent. So it's really weird numbers. And they're really, really high. I think it was 380-ish thousand registrations last year, and now we're up to 485,000 this year. So it's a huge increase, and all the numbers are weird, but they did eventually release those numbers. So let me amend my comments. I'm not saying the agency is terrible. But what I wanted to talk about is this new temporary restraining order that came out related to Title 42. This is a temporary restraining order, for those of you who don't know. It's kind of like an emergency motion from a person asking a judge saying, we need relief in this case immediately. Right now, judge, take everything off the table and look at this, because this is an emergency. It's a very high standard to meet. When we go and we litigate these things, we have to show quite a bit in order to win a temporary restraining order. So we don't do it in a lot of cases. To show that you're going to suffer irreparable harm, you're going to have to show that you have a substantial likelihood of success on the merits, and you just show that on balance, the public interest is served by the temporary restraining order being put in place. So it's a high standard. It requires a lot of briefing, it requires a lot of evidence, and it requires a lot of analysis by a judge. As background on what Title 42 is, it's a kind of a weird policy put in place during the Trump administration, basically saying, all right, we're not going to let folks in at the southern border because of COVID. Just kind of like unilaterally, we're not letting people apply for asylum because there's a risk of COVID being transmitted. Biden administration is trying to wind that down and actually get rid of Title 42. It was supposed to be in May. A lot of lawsuits, as you can imagine, have sprung up at the border states around this kind of rescission, and that's where this Title 42 temporary restraining order is coming from. Here it's Louisiana, and the judge was asked by the state of Arizona and the other states suing to halt the kind of like wind down of Title 42. So right now, the Department of Homeland Security is kind of using Title 42 less frequently to expel people who are trying to apply for asylum, and they're starting to kind of go back to their normal border enforcement procedures, so expedited removals, for example. And what this judge basically said was, can't do that, got to keep up with what you have been doing, and no wind down for you. It's a really weird opinion. To give you some context, I had a temporary restraining order decision a little while ago that was 19 pages long, had a lot of analysis into the types of injuries we were alleging, a lot of analysis into our success on the merits, if we were likely to succeed on the merits. And it was for one individual. It was not this sweeping large policy by any means. Here, it's a nationwide policy that all across the southern border, very large implications for thousands and thousands of people. And so, the judge in that one wrote 4 pages of analysis. And I would not even call it analysis. It was basically walking through the steps of saying, this is what a temporary restraining order is. I'm going to say yes to it. And then saying what the Department of Homeland Security has to do. The more you read about it and the more you read, it seems like every lawyer finds some new weird piece of information in there. I saw one that shows that it's actually requiring that the states are the ones that kind of say whether the Department of Homeland Security is doing the right thing and is complying with the order. They don't go to the court. They don't come and say, hey, I don't think this is being done properly. They don't make status reports that the judge then makes a decision off of. The Department of Homeland Security has to confer with the states to see if they are doing a good job in complying with temporary restraining order. It's absurd. The whole thing's absurd. It's just absolutely bonkers. The more you read, the more bonkers it gets. It's requiring the Department of Homeland Security to go back to the exact percentage of expedited removals it used previously, which is, I mean, that's a discretionary thing to even issue expedited removals. So to require a specific percentage of expedited or of discretionary decisions is yeah, it's bonkers. Everything is just crazy. It's the judge is overstepping into what the judge is able to do. It's the plaintiff's overstepping in what a plaintiff is able to do, and all of this wrapped up in 3 pages of text and just no legal analysis whatsoever. Just none. They don't talk really about the facts. They don't talk about the law, and this is just, it's absurd.
But how does it end up in this court, in this judge's court?
It's I would
Where does he get this power?
I would imagine it is a little bit of what's called forum shopping, where you're looking for the right judge to get you the right decision. This is in the Fifth Circuit, which is where we're getting all of the terrible immigration decisions recently. And what's even more strange is that I'm not sure Louisiana is a party to this suit. So what we have been seeing in some of these major challenges to DHS policy to either, I guess, increase discretion and, I guess, like enforcement through ICE priorities, things like that. We're just seeing these courts that really should not have any say in these decisions. There's no attachment to these courts making these decisions. So, for example, state of Texas suing the Department of Homeland Security, which is based in Washington, D.C., in the state of Ohio. There's no connection. I don't see how they possibly could establish venue in these courts. It's baffling to me. When if I was to make a lawsuit in even Washington D.C. right now, challenging some DHS policy or challenging a decision made by a sub-agency of DHS, they could come out and say, well, this doesn't have sufficient connection to DHS, so we're going to kick it back to where the plaintiffs reside. So really weird, really just kind of a strange, I don't know, it seems like double standard depending on who is suing and over what, which court is willing to hear you and whether certain laws are being applied in certain ways. Overall, this is just a strange decision. I think it signals that we're not going to be seeing the end of Title 42 anytime soon. But I guess that's a future Facebook Live update for you guys.
Is an appeal possible at this point?
Not over a TRO. Maybe if they get to the preliminary injunction that actually is, I mean, it's certainly going to happen, then they could appeal that. Maybe an interlocutory appeal is what it's called, but not over the Title 42 TRO specifically. This is where I think I guess even more background for folks. A TRO is only valid for 14 days generally, and then it has to be converted into what's called a preliminary injunction, which is longer lasting. So when that happens, and I say when and not if, then we might see some appeals, but then it's going to go to the Fifth Circuit, who's already made just absolutely ludicrous decisions recently, and then it might go to the Supreme Court right after that. So, I guess stay tuned. This is not going away.
Wow. It is like, yeah, this is a decision that is beyond bonkers. Like you said, I just can't fathom that this law, Title 42, was used in ways that were previously unthinkable and would cause outrage, and now it's just like the norm, and you can't do without them. I don't understand it.
Yeah.
So, all right, I guess we'll move into something which hopefully is a little bit brighter, and that's uniting for Ukraine. So a while back, the Biden administration announced that they had plans to accept up to 100,000 Ukrainians, and that they would be releasing plans on that. And part of the assumption, let me turn off the phone that's ringing. 1 second. Part of the assumption, I think, was that a lot of that would be done through humanitarian parole, which is the type of application that was used in many cases, but in large part for Afghans, and quite unsuccessfully, I would say. The program was not administered well, and there have been mass denials of those applications, and so there was fear that that this effort could result in the same thing. Well, this week they actually published information on their website on what Uniting for Ukraine would look like. And what they said is that it's going to work a little bit differently. Actually, what they call a supporter, and that's somebody here in the United States, starts by filing an I-134 declaration of financial support. And that's done online. They file this application on behalf of beneficiaries in Ukraine or who have fled Ukraine. The requirement is that they were living in Ukraine up to February 11th of 2022. And then the agency, USCIS, vets it to the supporter and the financial support and make sure it's sufficient. And if so, then they reach out directly to the beneficiary. And start to do some processing on information for the beneficiary. It's a little bit vague on what that's going to entail. And then they're going to contact the beneficiary directly if it's all approved, and they're going to be allowed to enter the United States for a period of 90 days. I'm sorry, the entry happens within a period of 90 days of the approval. Then once they're here, they're paroled in for up to 2 years. And during that time, they can apply for work authorization. To me, it looks like they don't need to go to a U.S. consulate at any time, that there's no visa issued. There's nothing similar to a visa issued. The travel authorization is actually going to be granted directly by the Department of Homeland Security, as far as I can tell. So the process is actually going to look quite a bit different from other processes. And the hope is that it will go smoother and faster than processes in the past. We will see. And I think it's very positive. I'm hoping that it works well for people. I can't talk about all of this without mentioning that it is grossly unfair to other applicants, and top of mind is the Afghan applicants who were promised that there would be support, especially if they had supported U.S. Government agencies or the military and were in danger because of it, or their families were. We've largely left them high and dry, and it's grossly unfair. And you can read into the different treatment of different populations trying to flee danger what you will. And I think there's a lot of underlying biases there that are quite offensive. But for the Ukrainians, I hope that it does work well, and that they process these applications quickly and get people here with, they're mostly going to be people who have family here, so that they can come be with family here and be in a safe place and get work authorization and then go from there. So that's that.
Yeah, I'm glad to hear that they've figured out a way to cut out the consulate part of it, because that was a big question when we were doing the humanitarian parole for people in Afghanistan. Is okay, they get this humanitarian parole granted, then where do they go for the visa? Because the consulate in Afghanistan shut down entirely, so they need to now get out of the country. And there were all these reports going around of violence happening at the border. So advising a client to try to cross a border anywhere, you could potentially be putting them in danger, even if, once they get out, they are able to go to a U.S. consulate and get the visa to actually enter the United States or the humanitarian parole approved. So I'm glad they figured out a way to do that. And yeah, I do hope that, that somehow this can be turned into something good for Afghanistan as well. We'll see. I wouldn't hold my breath for that at this point, but hopefully it can be used as a model for these types of situations in the future.
Absolutely. Zach, anything to add on Ukraine?
Nothing to add.
All right. Well, let's. It looks like there might be a couple of questions that we can get to before we call it a week.
First one from Irina. She is in Go and in Ukraine as well. And Charles Cook, I guess, said that a humanitarian parole is not a status, and we can't apply for adjustment of status. Does that mean that they need to fly to Frankfurt for the interview, or can we transfer our case to the U.S. consulate in Mexico? To please advise.
Zach, do you want to talk about adjustments from parole?
So I mean, Chuck's right. Humanitarian parole is not a status. It's just a way to enter the U.S. Once you have humanitarian parole, in order to kind of renew it, you need to show that you're able to normalize your status in one way or another, and that could be through an adjustment of status if you have a qualifying relative to petition for you. So let's say you're married to somebody who's either a permanent resident or a citizen of the U.S. You could have them petition for you to adjust your status, but by itself, it is not I guess, a means of adjusting status. There's no path from parole to adjustment of status. Instead, there are pathways from parole to getting to adjustment of status. It just requires to go through various other routes. So, like, for example, if you were to apply for and be granted asylum, that eventually would lead to an adjustment of status. If you, like I said, had a family member, you could apply to have that from your family member, have your family member petition for you to get permanent residency. An employer could petition for you as well. So it's just humanitarian parole is a way to enter the U.S., but it's not a permanent I guess solution to getting a green card or anything along those lines.
So
If you've been,
go ahead. Sorry.
I was going to say, if you've received humanitarian parole and you've gotten to the U.S., it might be something. TPS, temporary protected status, might be something to explore. They're pushing out the days at which you had to be in the U.S. in order to qualify for temporary protected status from Ukraine. So that's something that I would look into to see if you qualify. That again doesn't lead to permanent residency, but it's a longer term status. Beyond that, let's say that the visa gets released for you for go, and you're able to apply for adjustment status. You do have a lawful entry then at that point, and should be able to use that immigrant visa, that diversity visa, to adjust your status here in the U.S. Transferring between consulates is tricky, to say the least. Consulates aren't super, I guess, amenable to doing that right now, given their workloads. It's not impossible. You just have to kind of reach out to the consulates and see if they're willing to do that. But they're often not, and sometimes they'll just kind of cancel on you last minute. So
I think they might be a little bit more, hopefully, a little bit more understanding for Ukrainians. So maybe there'd be more movement there. The only other thing I would add is that the go orders. So say we're successful on appealing go, and there's a visa available to a go plaintiff. We can't be confident right now that that's going to allow for adjustment of status, because USCIS wasn't a defendant on the case. They haven't been ordered to do that, and we don't know that they'll have processes in place. So it may be that you need to consular process anyway. I don't know that for sure. It depends on what the final order looks like and how the agencies implement it. But if so, and you needed to consular process, you could try to get it to another consulate. All right, and then we have a trio of questions from Subi.
Yeah. Our new favorite fan.
Yeah.
She is from the DB22 case, and she's asking, is there anything illegal when the KCC doesn't give you interview appointment before they've processed your case? When there's a guide from December that says once a DS-260 is received for all applicants associated with a case, that case will be eligible to be scheduled for a visa interview.
Well, that's kind of the crux of the case, is whether they need to process these in good faith. So I don't think that there's, in an individual case, there's nothing necessarily illegal about not scheduling somebody promptly. But when it's systemic, and we can show that they are not processing these applications, and that they're on track to waste over 30,000, the hope is that that's going to push them to schedule people who have properly filed their DS-260s. The next question from Suvi is, when can we expect progress on the DB22 case? We're looking at a preliminary injunction. My best guess is that will be ready in the coming weeks to be filed, and that will be shared with plaintiffs. And then the last one is, do embassies know who plaintiffs are in the DV-22 case? Probably. Usually the government kind of shares the information that we provide with the complaint with the Department of State, and so they probably have that somewhere. Now, if you contact a consulate or an embassy or the KCC without flagging it, they might not have that information at their fingertips. We always say, you're welcome to identify yourself as a Bujabor plaintiff. It's not necessarily going to do anything for you at this point. There's no court order that's binding them to do anything for these plaintiffs, but you're welcome to identify yourself as such if you'd like.
Okay, that was the last question for today.
Excellent. Well, we will be back next week as always. And thank you, Rylan. Thank you, Zach. And thanks to everybody who's watched.
Thanks, everybody.
Bye.